Hello and good evening, everyone. Thank you for joining us. My name is Diana Cervera, and I am the Education Program Manager for California Lawyers for the Arts San Diego office. Welcome to today's webinar, Equitable Contract Considerations for Contractors and Artists, featuring Sam Mazzeo and Olivia Phillips of A Better Professional Corporation. I'm so excited to have all of you with us here today and about today's topic. I'm looking forward to learning alongside with all of you. I know there's so many artists and arts administrators and arts professionals in the audience tonight, so we're really glad that you're here. Before we jump into the webinar, I'd like to share a bit about California Lawyers for the Arts, which, as many of you know, California Lawyers for the Arts is a statewide nonprofit organization serving the arts community across the state by providing a number of legal and educational services. To share a bit more about our programs and services, I'd like to play a short video from our Executive Director, Alma Robinson.
Hello, my name is Alma Robinson, and I am the Executive Director of California Lawyers for the Arts. CLA is a statewide nonprofit organization that was founded in 1974 to serve artists and arts organizations of all disciplines with advocacy, as well as services that provide support with legal and business issues. With staffed offices in San Francisco, Berkeley, Sacramento, Los Angeles, and San Diego, we provide several core services. First, we provide legal counseling to specialized attorneys who provide assistance with a variety of intellectual property questions, as well as contract reviews and negotiations, and other important business issues. Depending on the client's financial status, legal assistance may be available on a pro bono or reduced fee basis. We also provide a specialized program that assists independent inventors and small startups with their patent applications. To help with situations involving disputes, we provide a range of alternative services, including negotiations counseling, mediation, and arbitration that can avoid the expense and hassle of going to court. Finally, we offer a full menu of educational programs that include workshops, symposia, and conferences on various legal topics for artists and arts organizations. Many of these programs are posted on our YouTube channel, and we encourage you to use these tools to educate yourself on the legal issues before you reach out for specialized assistance from our organization. Thank you for joining today's program, and please consider joining CLA on our website at www.calawyersforthearts.org so that we can continue to maintain our full range of services. Thank you.
Once again, thank you all so much for being here. Yeah, without further ado, I'd like to introduce Sam. Sam is a Renaissance man, but an approachable one. Some things that Sam can help you better understand are trademark, business formation and securities, contracts, Halloween party planning, and how to do a standing backflip. Sam, thank you so much for being here. Looking forward to your presentation. And Olivia Phillips is our other speaker that is joining us tonight. Liv is a Jane of all trades, working on mastering them all. Here are some things that she can help you better understand: labor and employment, contracts, copyright, the secret to a great guacamole, why SPF is important, and how to approach dogs you've never met before. Liv is also an independently certified HR professional. Sam and Liv, thank you so much for being here. As you know, I love working with the two of you. I think your presentations are always so accessible and informative. And as always, it's a pleasure to have you here with us.
Yeah, thank you. Always a pleasure. So you guys got a quick intro there with us. And I think we've seen some people in the attendees that have been in some of these workshops before. So welcome back. And apparently, we're not too boring if you guys are going to come to another one of these. So glad to have you here. And like I said, we're always happy to be here as well. We love, sharing information with this community and really just trying to be helpful for any of the communities that we touch with our law firm. So today we are going to talk about equitable contract considerations for contractors and artists. And this will be a little bit of a talk that kind of spans both the folks that are the hiring parties, so the people that would traditionally be actually hiring or engaging artists and contractors. But I think that it's also extremely helpful for those artists and contractors because you need to know, if you're the artist or contractor, what the party hiring you is thinking, what the pitfalls are, what the trip lines are, basically how to make sure that this works out and you have a contract that's going to serve you and protect you. So that's our goal today. Hopefully you guys will take that away from this conversation. We have to do our lawyerly due diligence here and let you guys, I'm not going to read this whole thing. It's incredibly boring, but you should read it. I'm just going to say this is not legal advice. We do not know your particular circumstances. Even when you guys ask questions, we don't know the specifics behind those questions and the full context. So we'll give answers the best we can from a really high level, general perspective. But, we are not your lawyers. We do not know those circumstances. And we definitely recommend that you do reach out to an attorney if anything you hear sounds like something that you need to go take care of. And we do free consultations, not to be salesy, but just in case you guys are wondering where to go to ask those questions, we'd be happy to help. So we'll kick it off here. I'm going to start with some general things that kind of get us into sort of how these different misunderstandings arise and sort of why this is an important topic to talk about. And really what that comes down to is that a lot of the time when you're contracting as an artist and a creative, whoever you're contracting with isn't an artist or a creative, and they typically have some sort of standard procedure, some kind of process that they go through with their contracts. Especially the larger the organization or business that you're contracting with, the more likely they are to have a legal department, a contract administration department, something along those lines that basically just says input A, B, and C, output X, Y, and Z. And they just have this system that they don't really have a lot of flexibility within. And that is always going to be difficult in any contract negotiation, but definitely when you're dealing with creative assets and creative work, because it's not usually going to be as standardized as what they're used to dealing with. So kind of further that point, different industries bring up different considerations. If you're a performing artist, you don't really need to go over revisions with the hiring party. But if you're creating logos, or maybe you're creating some type of copyright material, probably going to have revisions, and you should probably be compensated for those revisions. And, the same thing with deliverables. You would deliver a performance certainly a lot differently than you would deliver logo asset files or a script treatment or something along those lines. And all of what I was just talking about, those examples have different rules. Copyright has different rules than trademark. And then patent also has different rules than both of copyright and trademark. Now, I'll quickly go through the kind of definitions of those two. We see that those get confused a lot. We don't handle patents, so I'm not even going to cover those. But copyrights are original works of authorship fixed in a tangible medium, and then trademarks are source identifiers. Trademarks are a lot easier, of course, to kind of identify. I have a glass right here with Amoeba Music. That would be a source identifier. That's a logo. Hopefully that's not trademark infringement. And then copyright is, that original work of authorship fixed in a tangible medium. The example that I always use is J.K. Rowling when she came up with Harry Potter and Hogwarts. It isn't protectable until she wrote the books. Then the books became something that's a literary work under copyright that can be protected. And then once you have those rights in that work, you basically have a bundle of rights that you can give out. That's why she was able to license to Universal for amusement park and movies, and there's cookware out there now and all kinds of stuff, because she has a copyright that allows her to have that bundle of rights. So a lot of the time, this stuff isn't something that whoever you're working with is going to be something they consider. And there's just sort of, in addition to that, a fundamental misunderstanding about artists and creatives and the work that they do. We'll get into that a little bit, but it really stems from the fact that people don't realize that when they hire someone to do something like this, that's a creative nature for them, not only is that the artist's lifeblood, that's how they, support themselves, but there are those special rules around that intellectual property, and it's not just something that you would have like a widget that you contract for and deliver. So there's usually a fundamental misunderstanding in that respect, just about the nature of the work and the value of that work, which we'll definitely get into. But in addition to that, the way the relationship is structured actually makes a difference as to who owns intellectual property. And I keep using that, and I'm going to use it, intellectual property and IP interchangeably. Copyrights, trademarks, and really any other creative work that's a deliverable, patents included, would be considered intellectual property. So when I say IP or intellectual property, that is what I'm talking about. So I have lots of highlights and underlines and asterisks going on here, but that's because these things are important. So the underline is what I was getting at here, that the type of relationship by default in the law will dictate who owns IP. And this is a pretty commonly confused thing, or just something that people don't know. And it is by default that if somebody creating any type of creative work, any type of IP, if they are an employee of whoever they are creating it for, typically, and most of the time, that employer is going to own that IP. That's just the default. The way the law looks at it is in exchange for the benefits and payroll withholdings and the things that the employee gets from their employer, in return, the employer gets the IP that they create. Usually if it's related to the business, but that's not always the case. And then if you're a contractor, and we have the title here today is contracting with artists and creatives. So probably more likely that a lot of you guys are freelancers, have your own creative businesses, and you are contracted as an independent contractor, and the rules are different. And so in those scenarios, unless there's something in writing that says who hired you, who contracted you, owns that IP, they don't. You do as the creator, as the artist. And you can see down there the written agreement that I just mentioned. You can alter these default rules with a written agreement always. Contracts, you can think of them almost like your own personal legislation. So they can alter these things, really do whatever you want, so long as whatever's in the contract is not illegal. And so in the scenarios where you're contracted, if your agreement with whoever contracted you does not outline who owns the IP and it's completely silent on it, you most likely do. They don't. If it does say in there that they own it, then they most likely own it depending on that language. But there's some tricky stuff with this, and I definitely want Liv to talk to you guys a little bit about the independent contractor laws in California right now, which is enough for its own workshop. I think we've already actually done like 3 with CLA before on that topic, but I'll let her dive in real quick just to make sure everybody's on the same page with those rules.
Yeah, so echoing what Sam said, employees and contractors, they're different. Every once in a while, I have clients that come to me and they say I have a 1099 employee, which is not a thing. So just keep in mind mentally, an employee is here, a contractor's here. They're 2 different things, and there are different rules around each of them. Employees are covered under labor and employment laws, and contractors are covered under laws that are about contracts. And that's important because, like Sam was saying, a lot of the time we can contract around certain things. In employment law, that's not always going to be the case, but when it comes to IP specifically, you can. So just keep that in mind, that employees and contractors are always going to be looked at a little bit differently because they're looked at under different sets of laws. We will get into in a little bit, that I think is the next slide that Sam's going to go over with you guys. Contractors can either give ownership of IP, or they can keep ownership and give permission to use that IP in a particular way. So contractors really have a breadth of options available to them. If they grant permission to use something, the bundle of rights, like Sam was mentioning earlier, can look like various things. So contractors have a lot of options on what they can do when they create IP and how they want to determine the person hiring them, how that person can use the IP. So a lot can be done there.
Yeah, all really good stuff. We get a lot of people that think that AB5, the new contractor law, has been repealed and all these different things. Right. And so it is still out there. It is still a pain in the ass. It's not gone anywhere.
Yeah,
and I'm going to answer
that a little bit more throughout the presentation because that pops up all over the place. AB5, AB 2257.
We'll sprinkle it in.
I should probably throw this in too while we're talking about this before we get too deep into the presentation. Anytime I'm talking about contractor laws, those are going to apply to nonprofits and for-profits alike, unless I say differently. But across the board, for the most part, contractor law doesn't change depending on if you're a nonprofit or a for-profit. So keep that in mind while we're talking.
Yeah, good point to make. We get that question a lot. So moving on to ownership versus license, because this is also a big one. So you've got contractor and employee, and then you've got ownership and license. And there are many different sort of permutations of this where you can kind of like customize these things. But we're going to cover the fundamental ones here, and that's why I've got the little legal in the brackets there. So a license is going to be a situation where, let's say I'm hired by Olivia to create some cool logos, and I, in my contract, am only providing a license to use those logos on the window behind Olivia in her home. And that license then means that I maintain ownership and I can go use those logos for whatever I want outside of this relationship that I created them. But Olivia can only use them on that window in her home per the license that I have granted. Now, an assignment, on the other hand, is completely different. An assignment is going to be transferring all of the ownership. So when I said in that last example of the license, I retained the right to use the logos however I want. If I give an assignment to Olivia of these logos, she can use them wherever she wants, however she wants, whenever she wants, and I can't use them any longer at all. And so a lot of the time, what you'll see is that when you do these types of transfers or assignments, the assignment will come along with a license back to the creative for them to sort of like publish or display the work in their professional portfolios or magazines or design award shows kind of things. for their own professional recognition and for, making sure that their portfolio demonstrates the type of work that they do. Now, that license back to the creative is not automatic. It's one of those things that has to be in the written agreement, like we've been talking about here. So you'll start to gather as we go through this that this sort of entire workshop here is really kind of designed to illustrate for you guys that the devil's in the details, and usually that detail is in the contract. So making sure that if you do want the right to kind of display stuff in your portfolio, that you need that license back when you're giving an assignment. And then the other thing that I think is super important to talk about here, which I believe we'll get into in another slide, but I'll mention it here quickly, is that valuing your work is super important. Even as professionals and as a law firm, we constantly sort of look at our rates and try to determine, is that estimate that we gave someone appropriate? Does it actually provide for the time that we're putting in, our expertise, the experience that we have? And that isn't something that is specific and unique to a profession like ours. It's, I think, actually even more important and more sort of specific to artists and creatives, because you guys have such a specialized and sort of beautiful talent usually that, I can only hope to have. Really, I can't do anything other than like talk to people. That's my lawyer skill. So for you guys, you really need to spend some time thinking about and maybe looking around, talking to other artists. I think, the fact that Facebook's pretty evil, but there are groups on it that are awesome that you can talk to other people and get with other people and share and learn and sort of cooperate. And I think those types of things are really good for trying to figure out the value of your work, pricing your work, and really standing up for yourself in these situations and making sure that you're being compensated fairly for that work. So moving on here, I'm going to let Liv cover this one because she handles all of our labor and employment work for our clients. And this is kind of a employee contractor sneaky thing.
Yeah. And, I get asked pretty frequently if there are any like magic words or phrases that you need to look for in the contracts. I usually say no, but this is actually one that you do want to look for. And I don't know if it's magic so much as it is cursed, depending on what side of the contract you're on. If you're a contracting party hiring an independent contractor and you use a work made for hire clause in your agreement, it's cursed language for you. And that is because work made for hire clauses, which I'll get into in a minute and what you kind of look for there, but generally you look for that phrase, work made for hire. Work made for hire clauses are bad if you're trying to hire a contractor, because when you use this language in an agreement, that can cause that California-based independent contractor to become what they call a statutory employee, which is just a fancy way of saying an employee under the statutes or laws of California. And that's not good, because when somebody becomes an employee, that means they're entitled to all the benefits and protections of being an employee. So if you've kind of created this employee through your contract unknowingly, you are on the hook for workers' compensation, potentially for unemployment insurance and disability insurance, depending on, what happens in that relationship. And so if you are working with somebody and you have not gotten workers' comp, you are not paying into unemployment, you are not handling disability claims and things like that for this worker, you are not meeting your obligations as the employer of this statutory employee. So it's just a can of worms you do not want to open up. Like I said, the language always looks a little bit different on a work made for hire clause, but that's the phrase you want to look for, is those 4 words: work made for hire or work for hire, something like that. So we want to avoid that if you're trying to hire a contractor. If you're working with an employee agreement and you're hiring an employee, not a problem to include that language. And that actually might be wise depending on what the work that the employee is going to do for you is, because that's all part of copyright law and things like that. So again, really depends on the situation you're getting into. But if you're trying to hire a contractor, beware of the work made for hire or work for hire language. Sam put that little asterisk at the bottom. This highlights how important the language used in a written agreement can be, and I couldn't agree more. It's super important to make sure you've got a lawyer's eyes on this, because kind of seemingly unimportant language can actually matter quite a bit.
Yeah, absolutely. And I think, on the flip side of that too, for all the artists and creatives on this call, if you are inadvertently, classified as a statutory employee, could cause you tax issues, because then, there's supposed to be withholdings and things going on, and you maybe have a tax plan as a freelancer that you've already sort of handled. And it just can, like Liv said, create a whole can of worms that you really don't want to deal with. I'm going to move on to this next one. So the default ownership. So this is going to be, this license assignment or employee contractor, these different defaults. The reason that this can cause issues is that most of the time there's a misunderstanding. And like we've been talking about, whoever contracts you to create something, this first line is kind of what we hear all the time in these sort of negotiations or these infringement claims that we are, offering on behalf of our clients. It's, well, I hired them to create that. Obviously, I'm going to own that. And it's just not how it works unless the contract says so. Similarly, because you're our employee, we own everything that you work on, whether it's related to us or not. And that one gets really involved. There's a lot of employment stuff that goes into that, but a lot of the time, it's actually going to be limited to what you work on with their equipment and or on their time. And then sometimes if you sign an assignment agreement as you become employed by someone, it might be a really broad assignment agreement, and it might say something along the lines of anything related to what the company does will be owned by us. And that can get pretty serious for people. We've looked at those types of clauses for people that worked at Microsoft, and maybe they were creating an app. And, that's probably pretty arguable that Microsoft says, well, that's related to what we do. That's ours. And so it's very important, both in relation to the subject matter of today, which is, going back and forth on contracting over creative work, but also, for other things like, in addition to the contracting, that I totally lost that. That's crazy. That was it was a good little nugget that I was going to talk about too. So we'll probably move on to the next slide. Maybe it'll come back to me. All right. So we talked a lot about this already. I think this is tremendously important. It might be weird to hear from a lawyer that I'm saying, hey, value your work more, instead of me saying like, hey, get your contract drafted, which I'm also saying. But it's very important, and I find that a lot of the time we tend to be sort of like de facto cheerleaders for our clients, which we totally love, by the way. It's awesome. We get to work with people that do really cool work, create amazing things. It's super inspirational. If I'm being frank, my job's pretty boring other than the people I work with, Liv included, Diana included, but our clients especially. And so value your work. I mentioned earlier, it's good to be in communities and clubs and different sort of networking where you can talk to other people and get an idea of what they price their work at. And, we see it all across the board. We see people that come in and they dramatically undercharge. And then we see people that were like, holy shit, we're in the wrong profession. They're making so much money. So be like those people. Value your stuff. Make sure that you are standing up for yourself, and make sure that you're actually placing a value on the work that you create. Because remember, if it weren't for you, whoever's contracting you wouldn't have that thing you're creating for them. Right. Or it might not be as unique or as good as what you're creating for them.
Also remember, sometimes people bluff. Sometimes people will, guffaw at what you're asking them to pay for your work. And that's sometimes just a bluff. I've seen that. I love telling this story. I won't go into it too much. Had a client who tried to get her end client to pay a certain amount for a full suite of licensing for photographs that she took. Client said, no, that's too much. Your pictures were good, but they weren't that good, kind of thing. Ends up lowballing this artist, this photographer, and paying the bare minimum. My photographer client, kind of was like, well, I guess that's what my work is worth. And her end client ended up using those photos on a car wrap. So they must not have been that bad, because the lady was willing to drive her car around with the pictures plastered all over it. So, using that as an example of, sometimes people will tell you your work isn't worth it, but trust your gut, talk to your friends, talk to your colleagues. Your work probably is worth it, and people are just cheap.
Absolutely. And that goes to this bullet point here too, because what ends up happening is there's this sort of like self-reinforcing cycle where people, like Liv said, they scoff at whatever price you say, and then the artist back down and they're like, oh man, imposter syndrome. I guess they're right. It's not worth that much. And then that self-reinforces this idea that IP isn't valuable. And it also reinforces it with that hiring party as well as that artist. And then that just snowballs, right? And then it ends up being this situation where you never value it properly, and the people that hire never value it properly. And so kind of to that point, one of the things that we've been talking a lot about here is assignment versus license. I personally believe that there should be a different price for those two things. A license should be less expensive because it's a limited use. Ownership, if you assign ownership, charge more. They can go do whatever they want with it, as opposed to a limited subset of what they can do with it. So charge more. It's like that old saying, like give the farm away, the milk, the cow, whatever the hell it is. I always get these things wrong.
Well, it's like renting or buying. It's just
totally,
like that.
Exactly. That's so much easier. So make sure if you're only renting, it's a little bit less than if you're letting them buy. All right. I think this one's a good slide. I threw this in today because it's really easy in contract negotiations and these situations that arise to sort of assume nefarious intent. And I love the word nefarious, so that's why I use that. But really what I'm talking about here is like bad faith, right? Like when you're working with folks and you're going back and forth on the contract, and you're like, they will not give up this idea that I'm giving them ownership and I can only give them a license for this, and they're not willing to pay me enough, and like they must hate me, or like, why are they such assholes? What's wrong with these people? And a lot of the time it goes back to one of the things we mentioned earlier, which is just that they may literally not understand. They may not understand how intellectual property works. And their what appears to be bad faith is in fact just a mistake. And I even had this with a client recently that is a pretty, I guess, like pretty large scale podcast production company. And they were working with another large scale media company. And there was this confusion as to the end recording of the podcasts and whether or not that's something that someone can own, and whether or not our client retains ownership of that after they created it. And so we went back and forth for months and months on this. And it was very tough for my client not to assume that the other party was really just trying to be a... Luckily, in that scenario, it was a situation, and this is where this happens the most, where the legal team came in and they just didn't get it. Their contact at the media company got it. They were always on the same page. I'd been on phone calls with them and we were all in agreement. But then the lawyer drafts something not in agreement. And so it's the situation where there's mistake or misunderstanding. You know, I have this point here where just naturally, like everything that I'm saying on this workshop to all of you, you're hearing it differently than I'm saying it. Not to say that you're hearing it incorrectly, but we're humans and we interpret things and words and everything differently. You're all artists, you know that. Your art is interpretive. So that's one thing that contributes to this. And again, we're just going to keep beating this drum. Having a clear contract in place is so important. And I think, you know, like I have a few things down here to pay attention to here, because what you can kind of do is make sure that you're sort of cutting some of these things off at the pass if you start thinking about some of these little examples ahead of time. And then that way, and especially if you've gotten comfortable with, or you're working with attorneys that can do this, explain these things in a way that makes sense. And so that example that I provided with the podcast and the media company, I ultimately on the phone call said, what is the intellectual property that's the subject of this agreement if the end recording isn't that intellectual property? And I could almost hear the light bulb go on the lawyer's head on the other side of the phone, because they were like, oh yeah, it's that. Boom, finished it. It was a mistake. It wasn't bad faith. So happens a lot. And then something that I was trying not to say because I knew the next slide was coming, and so I'll say it now, is, you know, if you've started to have some similar situations come up, and this goes for, you know, anybody on this that hires people, but also for people that are creatives and get hired, if you're having some similar things that come up, whether it's like delivery or ownership, which we've talked a lot about, you know, revisions, the compensation license first assignment, if you've seen these come up, I know this is me asking you to do extra legwork that's like outside of getting paid and outside of what you do for your art. Go back, look at those emails, try to remember those scenarios, and make a list. Make a list of the things that keep coming up, and then make sure, if you're going to work with an attorney, that you give that list to that attorney, and that attorney makes those things exceedingly clear in your agreement so that you can avoid those pitfalls moving forward. And also work through that with the attorney. And just like as a side note, like if you have an attorney that's not willing to go through the contract they draft for you and like help you understand it, maybe not a good fit, just saying. So go through it with them and make sure that you also understand those things so that you can then avoid these commonly encountered issues with intellectual property negotiations, contracts, all the things. All right. So this slide's kind of really geared towards folks that are going to be hiring creatives and artists, but I think it's helpful for you to have this mindset as a creative and artist, because I've always found that, you know, going back to that point of the conversation that I had with the lawyer and saw the light bulb go on for them, a lot of the time businesses, organizations, certainly lawyers don't understand what creatives do and what they don't do. Yeah. And that's like, you know, just even beyond what intellectual property is and how it's owned and all of these things. But in addition to that, like if you create logos for someone, did you do a comprehensive US trademark search? Probably not. And that's something that you should have in your contract so that they don't come back to you if that trademark that you created for them is actually infringing on someone else's, even if it's not because you saw someone else's logo. It could be totally independently created, but still similar to another logo, and that's still trademark infringement. And you don't want them to come back to you and say, we're getting sued for trademark infringement and it is your fault. If you put in your contract, I don't do trademark searches, you need to go get that search. That is very helpful for you to protect you. And it also is helpful for them so that they know to go do that, and then they don't get sued and then they don't hate you. And that's probably a good thing. So, you know, we actually have some situations where we work with design agencies and we actually sort of are their trademark search outlet. and they will come to us, we'll run a search, and they'll white label our search report, completely scrape it of our branding and give it to their client. And they do offer those trademark searches to their clients through us. And that's totally fine. We're not in this for the PR here. We don't care if you scrape our branding from our trademark search report, as long as everybody's safe and everybody's getting their job done. So definitely making sure, similarly, like if you create a film or footage and you're probably not going to do a title clearance search. We don't even do title clearance searches. You got to go to somebody that actually specializes in that. And so there's just a lot of different things that creatives don't necessarily do that folks are going to think that you do just because they don't understand what the nature of your work is like. And, with all of that, this little asterisk down here, the reason I pause is that I talked about that in a previous slide, but I guess I got a little ahead of myself with making sure your contracts match up for assignment, license, all that stuff. Second to last slide, the penultimate slide. It's actually the ultimate slide with content, but I wanted to say penultimate. Don't focus on or get lost in the legalese. This one happens all the time. And in fact, I even have to stop myself from doing this because it is so easy to get caught in this trap. This trap is essentially that, and this is in a scenario where you have a contract. And essentially what ends up happening is that both sides are going back on the language in the contract specifically. That example that I'm going to keep talking about with the podcast company and the media company, that one was one of these scenarios. We were so laser focused on the contract language about the end product and who receives ownership and this distribution period and transferring ownership and buying out IP rights, that all we talked about was that for a couple of weeks. And at one point I just said, all right, this is getting us nowhere. We need to zoom out and we need to just figure out what it is that we're not agreeing on and what it is that we all need. And then that went back to what I mentioned, which is the end recording needs to belong to our client. They get a license to distribute it. Easy, end of story, less than a sentence. Or I guess that might have been 2 sentences. And that solved the whole issue that we had been struggling with for weeks, going over the legalese with a fine tooth comb over and over and over again. So always, always, always. And this is what we tell our clients when they come to us to draft a contract, focus on the what, not the words, not what you think needs to be in there. That's our job. And it's also our job when we help our clients with these situations to navigate through that, cut all the shit out and basically go, what's the problem here? What's the solution? Legalese be damned. We'll figure that out later.
Yeah. And Sam mentioned this earlier. I don't remember which slide it was, but this is also a really good time to make sure you have an attorney that you feel comfortable asking questions about, because often I have clients where I say exactly what Sam said. Tell me what you want to accomplish with this, and I will draft the language. And then they get this contract and they don't know how to message it to their end client, or they're not quite sure what they're reading. And at that point, it is okay to talk about the legalese, because that's your attorney and that's literally what you're paying them to do, is to help you understand what you're doing and why you're doing it. So in that sense, definitely talk to your lawyer, ask questions so you understand what you're getting into, so you can, confirm that what you said at the beginning is what you got at the end. And if you have an attorney who doesn't make it easy to ask questions, Sam said this earlier, maybe think about a different attorney, because this is your livelihood that you are contracting around. This is your life's work. This is your creativity, which is so personal. So make sure you understand what you're doing.
They call us counselors for a reason. We're here to counsel. And it's actually funny, that thing I did last night, I did like a startup mentor thing. And we talked the most, the bulk of the whole mentorship thing was how to work with attorneys, how to find a good fit, make sure they're a good fit. There's unfortunately, and this is true of every industry, but uniquely so maybe for lawyers, there's a lot of lawyers out there that are really good at selling you something and telling you what they're going to do. And then it's kind of not what they end up doing for you. And so, and unfortunately, that's sometimes even more true at larger law firms, because a lot of those types of law firms, they have the rainmakers, the ones that bring in the business, and it's not even who you end up working with. So there's inherently a disconnect between who you talk to and who does the work for you. And that's another thing, ask when you do a consultation with a lawyer and any professional that you're going to work with, ask them these questions. Are you who I'm going to be working with? Do you understand my industry? Have you worked on this before? We get these questions all the time. And I'll be honest, when I first started out and lived similarly, I remember us talking about it. You get those questions. And when you haven't worked on that before, that's a little uncomfortable. Yeah. And, we're not the type of law firm that just goes, oh, yeah, tons of times. We are the type of law firm that says, look, I'll be frank with you. I haven't worked on that before. However, I've worked on this, this, and this. I think they're similar. I'll do some research, not build to you, of course, because it's my own edification. And we'll get up to speed and we'll help you with that thing. And if they're like, nah, we want someone with experience, great. That makes sense.
Yep. Your lawyer's on your team. Remember that. They're supposed to be on your side, not on anybody else's side.
I kept writing in the chat of that thing last night, lawyer equals peace of mind. Apparently I type like this.
You look like a little deer prancing through.
Well, it's funny because my elder millennial showing, it makes me think of the Backstreet Boys or the NSYNC video from back in the day.
Since a creative may do similar work for multiple orgs or as their independent practices, when a person is hired as an employee within a creative organization, is there flexibility in negotiating the work for hire clause or creating some outlines around IP?
Absolutely, with an asterisk and a caveat, because we run into situations a lot where there's a difference between an institutional preference or requirement and law. And the legal answer to this question is yes, you can carve out any exception that you want. It's your content, it's your material, it's your creative work. Now, whether or not that organization or that institution is willing to do that with you, and whether or not you asking that will jeopardize the potential engagement or employment, that's a little bit different. You know, I think one of the most important things you can do, especially if like we're talking about an assignment agreement, when you're going to work for a company and they're basically like, you're assigning everything that you do for us and anything else that you've done. Usually there's a section, it's usually an attachment to that that says, what are your pre-existing intellectual property assets out there? Now, that one kind of sucks because you're not going to list out literally everything you've ever created in the history of your life, but you can kind of put some high level things in there about stuff you've created, stuff you've worked on that's unrelated to what you're working on, and you can carve that out from what you'll be assigning to them. Alternatively, another approach, or you can do both of these, is that you narrowly tailor that agreement, and we talked a little bit about this earlier, to make sure that it only reflects what you're working on for them or what you work on their equipment, or what you only work on during office hours with them, you know, something along those lines. And so I would recommend the negotiation there is, and this is actually a tip that I give people all the time. I think it's just an interesting thought observation on like human behavior, because in a lot of our conversations with our clients, I get these like really eloquent and like really articulate and very clear statements from our clients about why they need a thing. And then I go, you need to say that to them. Literally what you just said to me, say that to them. And so like, even in this question, it's like, just go to them and say, hey, look, I'm really excited about this opportunity. I'm stoked to create this stuff for you. I do create stuff for other people though, and I need to make sure that we're not jeopardizing my livelihood. Otherwise, let's work on this and make sure we carve this out and make it narrowly tailored so that you get what you want, but I can continue to do my work. And, you know, a lot of the time that's literally what someone says to me on a call. And I'm like, that you got to say that to them, or I'm going to go say that to them if I'm the one negotiating. So a lot of the time, you know, we have these, I don't know, monologues in our head that we think are just for us and that aren't helpful, but like really I'm a big proponent of put the cards on the table, tell them why you need something and tell them what you need. And then in all reality, like if they come back and they burn you on that, well, don't work for them anyway.
Yeah. I think a tip here, you know, as somebody who works in labor and employment specifically, and understanding what the onboarding process looks like for a new employee, because I'm assuming from this point of view that you're a new employee, you're signing all your hire paperwork, which has all this language. So from that point of view, as a new hire, you never have a better time to negotiate. That is your absolute best time. So, at that point, people are excited to bring you on. You don't have any negative interaction with anybody. So you really are at your best there. I would continue as much as possible to keep on that trajectory. Be honest with people where you can be honest. Don't pull any punches, let them know this is what I'm concerned about. And here's why, like Sam said, if you do have access to a lawyer, you can always loop them in behind the scenes so that you're not creating this tension with your new employer where they're like, oh, they brought the lawyers into it. I do that a lot for my clients where you guys are all arts buffs, so I hope you'll understand the reference, where I play Cyrano de Bergerac for them and I write out what they tell their employer, and they have an understanding of, I'm not going to get involved unless you ask me to get involved. You just take my info, take it to your employer, bring me back what they say, and we'll go from there. We'll kind of facilitate it that way. So, there's, like I said, it's the beginning of your employment. You have a lot of cards in your hand that you can play at that point. So I would say play them as well as you can. And if you don't know what to do, again, that's another time to loop in an employment attorney. They can help you understand what your rights are. I have had some people say, oh, I want to negotiate this, but my employer said I can't because I can't change that language because it's legally required to be in there. And that kind of goes to Sam's slide about mistake or bad intent. Sometimes the employer actually thinks that's the truth. They're not trying to pull the wool out over your eyes. They really think they can't make those changes. And then you can loop me in and we can talk together with the employer and help them better understand what the situation actually requires. So yeah, that was a lot in there, but I hope those tips were helpful in some way.
Can you give a ballpark cost to revise 2 contracts, one for clients, one for associates or people hired to do a part of a project? And then the second part of this one is the juicy nugget for us, which is the intent is to keep it simple. Current contracts are 1 page and don't include stuff like force majeure and indemnification clause. They should. I'm going to start there. We get the question all the time. I almost like have this like memorized, which is we get the question of, can I have a plain English contract? Can I just have a contract that just says, this is what I'm paid, this is what you get, and this is how we terminate? And we almost will never do that for you because we're actually doing you a disservice to give you a contract like that. And the reason for that is a few reasons. So one, if we draft a plain English contract, there isn't court case precedent determining what those words mean. And I know that sounds ridiculous. There's dictionaries and all that stuff out there. But in the law, the way that it works is there's court cases, they dictate how the law functions, and they create precedent. And if we do a plain English contract, contracts have been drafted in Legalese now for decades because these court cases dictate what the contracts have to say in order to achieve the goal that you have for the contract. And so in the event of a disagreement or a dispute over a contract that's in plain English, you can't go and say, look, there's a court case that literally says that work made for hire doesn't assign and it makes you an employee, or, you know, whatever the case may be. Whereas if you do have language in a contract that is language that courts have decided on, which is the legalese, unfortunately, you can look at a court case and say, no, the Ninth Circuit of California decided that back in 2000, and that language means exactly this, and that is the governing law of the land. So plain English contracts and really simple and short contracts kind of shoot yourself in the foot, if I'm being honest. A lot of the time, people have never had any issues with them, and that's awesome, great. But it's kind of like the whole jump off a cliff thing. Like if your friends do it, will you? Like just because you've never had a problem doesn't mean that you'll never have a problem. So it's really important to make sure that contracts do have things like force majeure, indemnification. I mean, for force majeure, I never expected to live through a force majeure event in my legal career, and we're currently in the 2nd year of one. And I can tell you for a fact, the clients that did not have force majeure in their contracts last year, much worse scenario than the ones that did. So having a built-out contract that's not a quick and brief one, I know that in the creative industry, you don't want to give someone a big scary contract, but at the end of the day, it protects them just as much as it protects you. And to kind of give you the ballpark, I mean, it sounds like that would be a creative services agreement and also an independent contractor agreement. Typically, we charge a flat fee of $900 for a creative services agreement and a flat fee of $500 for an independent contractor agreement. Those are agreements that we draft based on input from you that you then use time and time again. So it's not like it's like $900 every time you need to use that or anything like that. And then we're pretty good about not billing much when you come to us with questions on those because we drafted it and we know what's in there. Would you advise to use a lawyer to broker deals with galleries and museums, or do you believe that artists successfully advocate for themselves? Perhaps what are some of the mistakes, oversights you see artists make in these situations? Pretty specific question. I won't get too much into those details, but I do think that, you know, the rubric that I would give you on whether or not to use an attorney is the more money's involved or the more valuable the art, the more likely you should have an attorney involved. And, you know, it doesn't have to be a pure sort of financial calculation, but if you're getting paid $1 million to display some art at a gallery, $1,000 to an attorney is less than 1% of that, right? So, or whatever that is. I went to law school, not math school. So, you know, it's worth actually having someone take a look at that, because what if in that contract, it says that by displaying all your paintings at that gallery, you're actually assigning ownership to that. All your paintings are gone then, you know? So, and that's like a really egregious example. And then, you know, mistakes and oversights, that would be one, just making sure the intellectual property is dialed in correctly. You know, one thing that ends up happening that I see kind of often is like really mismatched payment terms. What if you have to pay people that contributed to the work and you don't have that money until you get paid by the end client, and then the end client's terms are net 90 or something, and you're not getting paid for 4 months, and then you can't pay the people that worked on things for you, and they start to try to sue you, and then maybe there's intellectual property disputes going on. Like a lot of it is just the logistics and the practical implications of the things in the contract are really important to look at. And, you know, with galleries and museums in particular, I would definitely recommend like having things in there about keeping the art safe, secure, temperature controlled. What happens if there's damage? What happens if there's theft? You know, those are things that you have to think about. And, you know, frankly, a lot of the time as an attorney, like we're just reading these agreements, and in addition to interpreting the language, we're just trying to think of like worst case scenarios. It's not, you know, a lot of the time our agreement review isn't rocket science. It's just, oh man, we've seen this before. I can think of a scenario where this happens, which, you know, it's great for when we let our minds wander about worst case scenario stuff for ourselves. But
I tell people all the time, we're professional rain clouds. That's what you're paying for.
Well, that's why I try to meditate and exercise a lot, so I ran a little less.
Is there a case where a contract can be amended between a contractor and an artist?
Yeah, I mean, look, back to that point that I made, I love this little soundbite that contracts are your own personal legislation, because it also lends some insight into this question, because absolutely, as long as both parties agree to an amendment and they sign that amendment, that's almost always going to be what governs then. There's sometimes a little bit of a tricky aspect to it, that sometimes if you change the terms, you need additional consideration, which means additional something of value that goes along with the changed terms in order to sort of modify that agreement and make it binding. But usually that's pretty easy to satisfy. If you change the terms of an agreement, usually that might change the compensation a little bit. That's consideration. So yeah, usually, as long as you can get both parties to agree to amend something, I would recommend having it in writing and having it signed by both parties. But yeah, certainly, I mean, at any point in time, you should be able to amend a contract. And that's another one where it's like, legally speaking, yeah, at any point, whether the other party agrees, different.
Yeah. And you would need to check also if you obviously have a written agreement in place ahead of this when you're trying to change that written agreement. They'll usually say the terms of what needs to happen to amend it. Like Sam said, usually it needs to be in writing or something like that. So make sure you check the language of the original contract before you try to amend the original contract.
Yeah, and a quick one on that too that just came to mind for me is like, if we're talking about a partnership agreement, which is different. So if you're sort of like doing a project together with someone, a partnership agreement's a little bit different. And it may, like, if there's multiple partners, it may require unanimous approval of all of the partners to amend it, which is typically true of like an LLC operating agreement or a shareholder agreement, something like that. What are moral rights? Should we be awarded with moral rights when working with European artist or contractor? So it's interesting that they included European artist or contractor, because moral rights, or droit moral, are actually something that grew out of the European legal system and not actually something that grew out of the US legal system. And in the US, so moral rights are essentially the right of an artist or a creator to control the outcome of their work. And that can take on a lot of different forms. That can mean that when they create something, they have a right to attribution or credit. They have a right to control how derivatives are made or transformative works. The problem with moral rights, kind of twofold, is that almost always, if you're assigning the rights, so you're assigning ownership of your IP to someone, they'll have a waiver of moral rights provision in that contract, meaning that you're waiving all of those moral rights with that work. But the other thing is that here in the US, at least, moral rights are very sort of ambiguous. They're kind of a gray area. And that is because of the fact that they are actually only covered by the Visual Artists' Rights Act of 1990 and then court decisions. So there is no sort of statutory moral rights in the US. It's more so that the US courts have looked at the VARA, that act I just mentioned, the Millennium Copyright Act, and just different sorts of rules around intellectual property in the US. And they kind of carved out these different sort of things with moral rights. And again, it really sort of deals with dictating the outcome of the work. But you should certainly take that into account with working with anyone out of the EU. And really, if you are the one that should be receiving ownership of IP, you'll need them to waive those moral rights. And then if you're the one giving up your IP, you really need to think about what that looks like if you don't want to give up your moral rights. And just kind of a practical note on that one, if you try to claim moral rights after you've given a license or ownership to someone, practically speaking, that could be a nightmare. Trying to then go chase down uses of your work publicly. We just had a client that did some creative work and didn't have the proper provisions in their contract, and it ended up getting used for a bunch of stuff they didn't want. And, tracking that down and dealing with that when it's a moral rights claim versus a infringement claim or unauthorized use claim is just going to be more difficult, especially given the fact that it's somewhat of a gray area and only something that courts have kind of outlined here in the US. Good question, though, for sure.
Isn't work for hire basically them trying to take ownership of your work? Absolutely. That's a great question. So that's why a lot of the time you'll see that in an independent contractor agreement. It shouldn't be in there, but people throw it in because they think, oh, if I add that language, that means anything that they create for me, I get to own. And as I explained, it actually doesn't accomplish that. It turns you into a statutory employee instead, which is not what we want. That's where, instead of work for hire, you'd want to make sure your independent contractor agreement uses an assignment clause, like what Sam just went over. They're different. An assignment clause, totally fine. And actually the standard for doing this correctly in an independent contractor agreement. And in that way, you're still the owner of whatever the independent contractor creates and has been assigned through that clause, but you're doing it through the correct legal mechanism. So that's important for everybody. Like Sam mentioned, if you're the statutory employee, it can be important for you to understand this. If you're trying to get the ownership through the contract, it's important. But yeah, great question. You're absolutely right. That's what work made for hire intends to do, is to get ownership.
And a little bit of backstory on that one that might be helpful for you guys too is that work for hire or work made for hire was traditionally the way to cause an assignment of IP. It's just been in the last few years in California that they've started to have some case decisions that have moved away from the work made for hire, partly related to the statutory employee situation, and really now only have it to where it's going to be a assignment provision that causes the transfer of the ownership versus that work made for hire. What are some advantages and disadvantages of creating an LLC for an individual art practice? And this is a preloaded question, but I'll try to do a good job of kind of like high level, give you the highlights here. And the number one thing that we're always going to say as attorneys when it comes to the question of should I have an LLC, should I have a corporation, is that it's going to protect you. And having that LLC or corporation in place, I always describe, and I think I've actually done a CLA workshop in the past specifically on this, but I always describe 3 lines of defense. And this is kind of a militarized example, and it's a little bit extreme, but it helps drive the point home, because what ends up happening is that there's sort of fundamental ways to protect yourself when you're doing business. And those 3 lines of defense, in my mind, are the primary ways to do that. The first one is a contract. Obviously, we're talking a lot about contracts, and we certainly recommend that you have a contract in place with anybody that money or services is exchanging hands, even trades. If you're bartering, I would recommend having a contract in place. And then the reason that's the first line of defense is that, the first place you're going to go in a dispute or to figure out who owns what is the contract. That should be, and this is what they used to say in law school, is that the contract, the 4 corners of the contract should be the entire agreement between the parties. And so everything should be in there. And that's where you should go to figure out in a dispute who's right, what's going on. Now, obviously, people say, I don't care, you breached the contract, or I don't care about the contractor. Sometimes if the contracts aren't signed, which for God's sake, people, sign contracts. Make sure you have signed contracts. We get so many people that come to us and they go, oh, here's the contract. They're so out of line. And it was never signed. And that's a whole thing. Sometimes you can still enforce it, but I think people sometimes are like, yeah, we had the contract exchange. It's good. Sign it, sign it, sign it, sign it. Please sign it. So contracts are first line of defense. Second one, insurance. Sometimes with the different types of creative work that you do, it might be hard to find a specific policy that works for you. But nowadays, the insurance companies are slowly catching up, and they understand that there's risks with digital work and there's risks with copyright on the internet and things like that. So there might be an insurance policy that really covers you for the type of work you're doing. And that would be the second thing. If there's a lawsuit or the contract was breached, hopefully the insurance covers you. They step in, they handle that. Of course, insurance is notorious for not paying out and covering things. So the last line of defense, the third line of defense, is that LLC or corporation. It is the backstop protecting you from personal liability for anything that you did as a business. And so specifically to an art practice, having an LLC in place can be really helpful, not only from that protect you scenario, but also tax write-offs and deductions. Usually that can be a really helpful thing, maybe save you some money. In addition to that, a lot of the time as artists, and going back to the sort of valuing your work and standing up for yourself, is as absurd as this may sound, sometimes when people hire artists and they do have an LLC and they have themselves set up as a business, people take you more seriously. It looks more formal, looks more professional. And not to say, go out and spend $1,000 to set up an LLC to look more professional. But if you're hearing that, oh man, maybe I should protect myself, maybe you do work where someone claimed there was infringement once, the LLC could hopefully protect you against that. So all of those types of things, protection, tax advantages, deductions on taxes, professionalism. You might be using your social security number right now for taxes and sort of vendors and 1099s and things like that. You can use an EIN instead, even as a sole proprietor, but certainly as an LLC. So I do think there are advantages. Disadvantages, the cost. You got to set it up. And then also annual maintenance. A lot of the time we get people that think it's kind of set it and forget it. And then there's a whole bunch of penalties and stuff that you got to deal with, because with an LLC, you have to file a statement of information with the Secretary of State every other year. And it depends on the year you're formed. So if you put an LLC together this year, it's an odd numbered year. So every odd numbered year, you'll have to file that statement of information. You also need a business license, which you need as a freelancer too. So if y'all don't have that, make sure you get that. That has to be renewed every year. And then if any of your art is actually tangible, if it's a physical item, you need a seller's permit. Seller's permit, you just have to report sales and pay tax on that quarterly or annually. Doesn't have to be renewed. And then taxes, generally speaking. When you form an LLC, California triggers something called the California minimum franchise tax. Starts at $800, goes up based on your revenue. I believe it is capped at $2,500, but that is also for like 5 million plus in revenue. So hopefully you guys are out there doing that, and then it's only 1% of your revenue. But something to consider, the disadvantages are primarily cost and maintenance for having that entity or LLC or corporation in place.
And I have one advantage to throw in there. It's similar to the just giving you a little bit more of an air of professionalism. It's very similar to that. But on the flip side, when people are looking at who they can hire as an independent contractor in California, having a business entity usually makes people feel a little bit more confident moving forward with hiring you as a contractor. So you might be able to actually get more work that way. It's not required by any means to be contracted to have an entity. What actually is more important there is that you have a business license. The law looks at that a little bit more critically, but it sets people at ease a lot more. They feel that it's easier to hire LLCs or corporations because it's pretty hard for an LLC to argue that the LLC should have been an employee. So it does make people in the hiring position feel more comfortable and sometimes can lead to more work for you. So that's a possible advantage as well.
What if there's no contract? There's a group of artists, they all created something together. They no longer collaborate. Who owns what was collectively made? And then who owns the name that they were doing business under? And then in addition to that, can someone say that footage that they collectively previously made, can someone say that no one can use that or only someone can use that? And I'll just kind of go in order here. So the owners of that work are everyone, that entire group. So when there's no contract in place and everyone worked on something together, typically the law applies a default sort of collaborator classification of that. I'm using classification really informally here, but essentially what they do is they look at that and they say it's collectively owned, and everyone in that group can go out and monetize it themselves all they want, but they have to report back to the other owners and you have to share the revenue. So it can get very complicated, very confusing, and very, tense, I guess you could say, between people in that scenario, because they may not know that. They may go out and monetize it, and then the other artists are entitled to some of that revenue. So, and there's factors like we've been talking about that can impact this, but that's the default. And then doing business as, if somebody actually filed for a DBA, they're usually called fictitious business names in California. If someone actually filed for that, it's whoever filed for it as the registrant of that FBN, fictitious business name. If you guys were just using a name publicly, no one owns that. That one's different. That's a different rule. The name of a business, technically it falls into trademark. And then that gets even more confusing and complicated because it's whoever used it first. And if you all used it together, very, very complicated sort of analysis to determine who owns that name. And there's some tricky strategy with trademark. Somebody could run out and file the trademark application and technically gain ownership of it. And then if there's footage, can anyone say that no one can use that? And typically the answer is no, because of the fact that everyone owns it collectively and you can monetize it independently, but you have to report back with that revenue. So you can't necessarily prevent others from using it, but you should have a claim to the money that they make if they use it, assuming that, the facts here are everyone kind of created it equally and, somebody's out there monetizing it. Like I said, this one's a doozy. Hopefully that was a little bit helpful. It's a lot to get to on that one.
Yeah.
If you're making work with the physical assistance of volunteers, is the IP shared with them? How does the artist maintain IP working with unskilled volunteers? The physical part throws me a little bit on this question, but the answer is going to be the same. Anytime you're working with anyone, volunteers, whatever it is, if you're sculpting things, if you're making footage, if you're creating logos, I was just playing with an Oculus headset earlier, if you're making VR, anything that you're making, if you have volunteers, employees, interns, contractors, make them sign an assignment agreement if you are going to assign that intellectual property. And that actually highlights a really good point that I'm glad that you brought up here, which is that we've seen before, and this happens relatively frequently, where there's a mismatch of the agreements that somebody's working on with IP. So an example that we've had in the past is, let's say you've got a publication online and it's maybe a really heavily trafficked blog site, and you've got contributors and they're all contractors and you have a contract with them. And then you have some maybe big companies that you're going to do specific blog write-ups for that they need to own. Maybe those are going to live on the intranet for that company, or you're doing some copy for them that they're going to repurpose and they don't want to give you credit, so they're going to own it. You're going to assign it to that end client. If you don't have an assignment from the people that contributed, you only have a license, but then you give ownership through an assignment to the end client, that's a problem, because these people over here still have ownership rights in what you just assigned ownership to. And that is a whole can of worms. We keep saying that because intellectual property is always sort of a bundle of things. It can be a can of worms pretty quickly. So make sure that your contracts all match up. And this is a great question to highlight that, because no matter who they are, no matter what they're doing, you'll want them to sign either a license or an assignment. Almost always going to be an assignment, because then you are free to do what you need to do with that end product, that intellectual property that likely you're also contributing to.
If a recurring client signed a contract several years ago, will that contract apply to future projects, parentheses, as long as there are no changes? And the answer to that is one you're probably not going to like, and it depends on the language of the contract. A lot of contracts for deliverable-based services, some service-based services as well, will have something like a statement of work or a scope of work, and usually that main agreement might say, this agreement governs the attached scope of work that we're including and any future scopes of work. In that case, the answer here would be maybe, depending on if there was an agreement term length or something like that. If it's one big main agreement that doesn't have clarity around what services are included for that agreement, I would say that contract might not cover future projects. It will really, as you can see, there's different scenarios. And so it really does come down to the specific language in the contract. I will say, though, if you're dealing with a contract from several years ago, we usually don't recommend having contracts that are that open-ended. I usually like to have my clients have a contract that maybe covers the span of a year, and then at the end of that year, a new contract gets re-executed. And that can be the main service agreement with multiple scopes of work under it. But it's just a good idea to re-execute contracts more frequently than every several years. Laws change, people change, their circumstances change. That's a great time to negotiate for higher rates. We had a pandemic. We're still in a pandemic. That might be a great time to revisit your force majeure clause if you're doing something that's deliverable based on a schedule and you want some flexibility there. So if only for that reason, to be able to update terms, we usually recommend having contracts re-executed annually is, like I said, what I usually recommend.
Totally. And it's a good thing to also mention on that point too, is that, you should view everything nowadays through the lens of the independent contractor laws too, because having an indefinite duration of an agreement, it kind of looks like employee. So something to think about there. Trademark searches are easy. Why wouldn't a logo designer do that? Same with searching web addresses. Always have to sort of preface this that I'm not saying that your search is bad or that you're not smart or that you don't know how to do a search. So even in this question, there's some misunderstanding. Web addresses have nothing to do with trademarks. They actually do not support trademark registration. They are not evidence of trademark usage. They are completely unrelated, except for if you have a registered trademark, sometimes you can bounce someone out of a web address and get it with your trademark registration, but they don't support trademarks. So I would recommend against searching web addresses if you're doing that as a part of a trademark search. And then trademark searches themselves, a lot of the time people come to us and they say, oh yeah, I searched the test database, the trademark electronic search system through the USPTO. I can tell you right now, I've been practicing trademark law for 10 years now, and I can't function the test search appropriately with all the terms, connectors, search methods, and permutations of how you search. We're actually trained in law school to use crazy things like an asterisk at the end of a word to search for all conjugations of that word, ing, n, ed, all of those. Then brackets to make sure you're not searching a word with these other words, and then parentheses to make sure you're including these words with that word. And I still can't search tests comprehensively.
Yeah.
What we do is we use a combination of platforms, tests included, that have algorithms that do these types of searches with machine learning and with AI and with algorithms that do it far more superior than we could. And then the most important aspect of it, which all of that's important, but the most important aspect of it is we then review the reports that get spit out by those algorithms and those search engines. And that's where the sort of, the secret sauce is, I guess, so to speak, because I've personally filed over 600 trademarks. I guest lectured a trademark class 2 weeks ago. And the only reason I bring that up is it was really interesting in the curriculum reading for that class because it's the preeminent textbook on trademarks. It's called BB, and it's from a case that was decided a long time ago. And in that book, it actually says trademark lawyers develop a feel for trademark more than there is a black and white rubric for trademark. And that is absolutely true. I do education sessions for my staff all the time. And every time I do a trademark one, there's lots of questions that get fired at me. And there's not clear answers in trademark law. So a trademark search, it really is about the interpretation from someone that understands those rules, how the USPTO responds, the fact that examining attorneys at the USPTO are just humans, they're wildly inconsistent, and just the different standards that go into it. I learn something every day about everything that I do in the law. And so again, not to say that someone's search is bad or you don't know what you're doing. It's just a different type of search that you're going to get from an experienced trademark law firm than you would get on your own. And that goes for some other things out there too. Like I think someone came to us recently and they worked with Trademark Engine, I think it was called, something like that. And they're like, yeah, we paid $150 for a search and a registration. What? Not only is a search typically far more expensive than that, it isn't with us. We're $200 for a word mark and $300 for a logo, but a lot of law firms charge upward of $1,000 for that. The thing that made me do a double take on that with that client is that a trademark registration, the filing fee with the USPTO alone is $350.
Yeah.
So if they paid $150, I don't know what kind of search they're getting, and I don't know how they filed an application with USPTO. So beware of those things out there too that are like, we're a comprehensive search engine and it's only $50. Maybe have a lawyer look at that if you're going to spend that money on that. And even in those scenarios, we've had people send us the search reports and we end up doing our own because it's just a very, very specialized area of the law. I think the two most specialized areas of the law that I practice are securities, which is investment stuff, and then trademark, and then live with labor and employment. It's incredibly involved as well. What are some low and high cost and low and high maintenance strategies for protecting workshop and course curriculum and then writing and or theory that we might develop as an artist? So I'm going to work backwards on this one. Theory can't be protected unless it's written down. Remember, original work of authorship fixed in a tangible medium. So if these things are written down, the best thing to do, include copyright disclaimers on everything. That doesn't do anything, so to speak, but it does put people on notice. It doesn't like create copyright rights for you or anything like that, but putting the C on there and putting the copyright claim on the work that you have, whatever it is, does notify anybody that sees that work that you intend to protect your copyright. And what that does for you is that it can create a situation where that's intentional unauthorized use or infringement because there was a notice on it, and the law presumes if they saw the notice, or rather that if you put it on there and they used it, they saw it. And so then it makes it a little bit more of a slam dunk, so to speak, of infringement or unauthorized use. And that's pretty low cost, low maintenance. Same with like watermarks on photos and things like that. There's a lot of metadata stuff now that you can do, which is outside of my realm of understanding. I'm an elder millennial, so technology's like, I get some of it. So metadata, things like that, those are other ways to do it. The high cost and the high maintenance options are registering it with either the US Copyright Office or the USPTO, the Patent and Trademark Office. Copyright applications are actually the least expensive intellectual property application. What's that?
They're pretty affordable. Yeah. Compared to trademark, copyright's a lot more affordable. I didn't mean to interrupt, but you also have to remember copyright doesn't cover everything like Sam said. Anyway, Sam, take it away.
Yeah, and copyright's a little bit easier for people to kind of like finagle around it because copyright's pretty specific. And like, if you think about copywriting, for instance, curriculum, if they change a couple modules of the curriculum, is it then still the same thing? I would say yes, that's a derivative work and there's still unauthorized use of that curriculum, but it's a little bit more of a stretch, a little bit more of a walk sometimes with copyright. And then there's other things like fashion, jewelry, clothing. If you copyright something, by the time it actually registers, copyright's like an 8-month plus process. By the time it registers, that's out of fashion. Why even register it at that point? Not to say that, like, I'm pretty sure, what are the heels that have the red bottom?
Louboutins.
Those are an actual trademark. They registered that red bottom of a heel as a trademark because it's so recognizable. When someone sees that, except for me apparently, they know that it's Louboutin. So that's kind of an example of different ways that you can kind of protect these things. I always think of intellectual property on a spectrum. At the low end of the spectrum is the rights that you get under common law. Common law is what you get just by putting it out into the world. So as soon as you publish copyright, as soon as it's out there, you have common law rights in it. They're not as strong as registration, but you have some rights in it. Same with trademark. Once you use a logo or a word mark, you have rights in it under common law. They're just not as strong as they would be if you registered. So I think those are kind of touching on that one, some low and high cost maintenance. The whole thing that I've heard about people like mailing themselves a copy of the copyright stuff, that doesn't hold up. I mean, like, I can go get a stamp and make it look like a postal stamp and stick that on an envelope with a stamp and like act like I mailed that to myself. So you just got to kind of think through some of those things that you hear out there that just don't hold up like that one.
That one, I think they call that one the poor man's copyright.
Something like that.
Something like that. Yeah, not a thing.
It's a no copyright.
Yeah. That's the poor man's way to get even poorer because they just wasted money on a stamp.
you have to register your copyright to take someone to court for infringing it. Not necessarily. The big thing that's really helpful, though, if you have your copyright registered, is there's statutory damages. And statutory damages are going to basically just dictate how much money you're going to get. And there's a different formula. There's a few different formulas in the statute, but it makes it sort of have more teeth when you have something registered, because then you essentially have the backing of the federal government saying you own that thing. And so not only is that more significant to get someone to stop using it or infringing or, sharing it out there, because you can say, hey, look, here's my certificate from the federal government showing that I own this, stop using it. But in addition to that, you can add to that sort of messaging, and I have statutory rights and I am entitled to statutory damages for your use. So stop using it or you're going to be in trouble based on the statute. Now, there's other ways to calculate copyright infringement. It could be based on how much you would have sold that thing for. But, those statutory damages are really helpful. And again, the most important aspect of those registrations is that you have a neutral, unarguable third party that says you own that thing. And that usually is sort of what will prevent you from having to go to court, because you can send it a cease and desist or a message and say, this is mine, stop using it. And hopefully if they have any sense, or they have a lawyer that has some sense, they're going to tell them, hey, they have that registered, you are infringing, stop before they sue you, because they can sue you. So a lot of the time, it's all about making them stop before going to court.
Great. Thank you all so much. I think a takeaway for me, definitely from this, is just thinking about equity, right? Kind of circling back to that and really thinking about some of the things that you all shared, just becoming more standard on both parties, sort of like, I think sometimes folks might have a misunderstanding that like we need to talk about legalities when there's a problem. But I think in fact, it's kind of a lot like everything you covered is just kind of like walking into an agreement, just more informed to sort of avoid some of these issues that maybe come up later because of like confusion, etc. So like a huge takeaway for me, just kind of connecting this back to equity, and why I'm so passionate about like doing these workshops and having you all here with us is just that artists and arts admins can walk away with that sort of like, let's just talk about it at the start, right? Sometimes things are just like, a standard blanket contract, and that doesn't work for everyone. So
artists should have a seat at the table, and that's what equity is. So if you don't know what to talk about at the table, it's hard to have that seat. And so hopefully this empowers some of you guys. And like I said, we're certainly kind of cheerleaders for our clients, and we'd love to help you guys get your work out there. So please let us know if you need any help with any of this stuff. But yeah, I mean, it's definitely something that we see often, as you can tell from all of our little examples and anecdotal experience that we've had.
Mm-hmm. Again, a huge thank you to Sam and Liv. It's always an excitement to have you all. I always learn, and it's just, I just love presenting you all with California Lawyers for the Arts. Thank you for attending. Thank you, Sam and Liv, and I hope you all have a great night.